What if permits to carry firearms in America vanished overnight? Because the Supreme Court, in a stunning 9-0 emergency decision, just wiped permit laws off the map, with the Department of Justice and multiple states cheering it on? This isn't a hypothetical. We're witnessing the collapse of a century-old permit regime, as the nation's top court calls it unconstitutional, and triggers a chain reaction powerful enough to shake every blue state stronghold and unravel a billion-dollar industry in days. The era of forced permits may truly be ending. But how did our entire legal system fall so fast? And what happens when the dust finally settles? Let's break down the stakes. At the dawn of the 20th century, American lawmakers began to lay the first bricks in what would become a towering permit regime. Cities like Boston and New York led the charge. In 1906, Boston's City Council passed an ordinance requiring a license to carry pistols or revolvers in public, setting the original fee at just over $1. New York followed in 1911 with the Sullivan Act, mandating a police-issued license for any handgun carried outside the home. That license cost $3, a sum that, adjusted for inflation, would be nearly $90 today. But the real price was paid in paperwork and police interviews, as applicants had to prove good cause to local authorities before a permit would ever be issued. Chicago joined the movement in 1913, charging $2.50 for an annual permit, while San Francisco and Los Angeles adopted similar systems soon after. By the 1920s, nearly every major city from the Northeast to California had locked public carry behind a wall of fees, forms, and official discretion. The process was rarely simple. Applications required personal references, background checks, and sometimes even an interview with the police chief. Renewal fees and late charges stacked up, turning what started as a modest administrative cost into a recurring tax on the right to carry, one that grew steeper with each passing year. State legislatures took notice. Massachusetts and California codified these city rules, spreading permit requirements across entire states by the mid-1930s. By 1940, the majority of urban Americans lived under some form of police-issued permit law. Supporters claimed these measures tamed the so-called Wild West of city streets, while critics called them a poll tax on constitutional rights. But the system took root. Permit fees, interviews, and background checks became the norm, entrenching a culture where the right to carry was no longer automatic, but something to be requested, paid for, and, sometimes, denied. That is how the permit wall was built, brick by bureaucratic brick, until nearly every city and state had joined the fortress. The cracks in the permit wall didn't appear overnight. Legal scholars warned for years that the system stood on shaky ground, held together by precedent that was already starting to buckle. The Supreme Court itself began to draw new lines with a series of landmark decisions. In 2008, District of Columbia versus Heller declared that the Second Amendment protects an individual's right to possess firearms for self-defense. 2 years later, McDonald versus City of Chicago made it clear that those rights applied in every state, not just in federal enclaves. But the real turning point came in 2022, when New York State Rifle and Pistol Association versus Bruen forced courts to abandon the old balancing tests and instead measure every gun law against the history and tradition of the founders. The message was simple. If a restriction didn't exist in the 18th century, it would be hard to justify now. Legal journals called Bruen a revolution. Judges across the country began to strike down permit requirements that relied on subjective standards or long delays. State attorneys general scrambled to defend their laws with whatever historical examples they could find, often coming up empty. Law reviews filled with warnings that the permit system, once thought untouchable, was now on borrowed time. Even the Department of Justice quietly changed its tune, with internal memos hinting that permit regimes were legally fragile after Bruen. By the summer of 2025, the stage was set for a final reckoning. The Supreme Court, having watched the chaos unfold in the lower courts, prepared to weigh in with a decision that would sweep away more than a century of bureaucratic control. The legal ground was shifting, and everyone, lawmakers, activists, and ordinary citizens, could feel the pressure building. The Department of Justice did something no one expected. Instead of mounting a defense, the DOJ issued a memo, stamped and circulated to every federal prosecutor, declaring permit-based carry systems indefensible under the new Supreme Court ruling. The language was blunt. Continuation of such requirements is incompatible with the court's interpretation of the Second Amendment. This was not just a legal retreat. It was a full-scale institutional pivot. For decades, the DOJ fought to uphold permit regimes, arguing they were essential for public safety and law enforcement. Now, the same office was instructing agencies to dismantle the very barriers it once defended. Internal emails revealed the calculation. DOJ attorneys, after reviewing the court's unanimous opinion, warned that any attempt to defend permit requirements would almost certainly fail in court. One line from the internal review summed it up. Permit frameworks cannot survive under Bruin's historical analysis and the clarified majority opinion in Wendell. But the DOJ wasn't standing alone. 15 states, led by Florida, Texas, and Montana, filed a coalition brief with the Supreme Court. Their message was clear. Forced permits for a fundamental right violate both the Second and 14th Amendments. The brief pointed to real-world data. Since adopting permitless carry, these states had not seen a statistically significant rise in violent crime caused by lawful carriers. The coalition urged the court to erase the barrier for all Americans, arguing that history and experience were on their side. The court noticed. In its opinion, the justices referenced the breadth of state support and the DOJ's agreement as proof that the old permit system had lost its defenders. What followed was a nationwide scramble. State legislatures, sensing the federal green light, began rewriting their own laws to comply. For the first time, the roadblock to carry rights was not just crumbling. It was being bulldozed by the very institutions that built it. State houses lit up with emergency sessions. Governors from Florida to Montana ordered immediate reviews of every statute tied to concealed or open carry. Within days, Florida's legislature introduced a draft bill wiping out the state's entire permit code, citing the Supreme Court's opinion word for word. In Texas, lawmakers filed an emergency amendment to recognize constitutional carry in all public spaces, even those previously barred by local ordinance. Montana's Attorney General issued a directive to county sheriffs. Effective immediately, no agency may require a carry permit for any law-abiding adult. Tennessee's judiciary sent guidance to every circuit and municipal court, instructing judges to dismiss pending permit violation cases and expunge convictions based solely on permit infractions. The momentum didn't stop at the state level. Lower courts began issuing orders to halt enforcement of permit-based restrictions, sometimes within hours of the Supreme Court's announcement. In South Carolina, a judge granted an injunction blocking the state police from processing new permit applications, declaring the process obsolete. Alabama's governor called a special legislative session to propose a constitutional amendment guaranteeing permitless carry as a permanent right, no matter who controls the federal courts in the future. Oklahoma, Idaho, and Arkansas followed suit, each racing to enshrine the new standard in state law. Judicial guidance from coast to coast echoed the same message. The age of permission slips is over. Emergency legislation texts reference the Supreme Court's language line by line, leaving no doubt about compliance. In just 2 weeks, more than a dozen states had either suspended or rewritten their permit laws. What was once a patchwork of rules became a wave of freedom, rolling across the country faster than any gun rights expansion in modern history. This was not a slow evolution. It was a surge, swift, decisive, and unstoppable. The financial shock hit before the ink was dry. Across the country, permit offices switched off their phones, websites crashed under a flood of confused visitors, and the billion-dollar permit industry found itself staring into the abyss. County budgets that once relied on steady streams of application fees, $50 here, $100 there, suddenly faced gaping holes. In Florida, where permit fees brought in nearly $55 million each year, revenue projections were slashed overnight. Los Angeles County, with its $7 million annual permit budget, began preparing pink slips for dozens of clerks and administrators. But the pain didn't stop at government offices. Instructors who built their livelihoods around mandatory training watched their calendars empty out. In Texas alone, over 1,500 certified instructors reported mass cancellations within a week. Some pivoted to voluntary classes, but most saw no way to replace the lost demand. One instructor in Miami described it bluntly: 70% of my business evaporated in a day. Shooting ranges that once hosted packed weekend certification courses now stood half empty. Insurance companies scrambled to rewrite risk models. Without state-sanctioned vetting, premiums for concealed carry coverage jumped by as much as 20%. Brokers fielded calls from policyholders worried about losing their discounts, while new applicants faced higher rates and stricter terms. Meanwhile, small businesses offering fingerprinting, background checks, and notary services for permit paperwork watched their client lists shrink to a fraction of what they were just days before. County sheriffs, already stretched thin, warned that lost permit revenue would force cuts to community programs and even layoffs in some departments. In Illinois, one sheriff's office projected a $2 million shortfall with no plan to fill the gap. The message was clear. The old system wasn't just a set of rules, it was an economic engine, and its sudden collapse sent shockwaves through every corner of the industry. The scramble for answers had only begun. The gun control lobby didn't wait a single day. Everytown for Gun Safety called the Supreme Court ruling a national crisis, blasting urgent fundraising emails to millions. Gifford's PAC pledged $20 million for a legal war chest, promising to fight the decision in every legislature and courtroom that would listen. Brady United, another heavyweight, rolled out a campaign demanding new laws to designate schools, parks, and government offices as so-called sensitive places, a last-ditch effort to keep public carry in check. But it wasn't just the big names. Grassroots activists flooded state houses with petitions and staged rallies, especially in blue states. In New York, activists drafted model bills aiming to turn nearly every public gathering into a gun-free zone. California lawmakers rushed through emergency sessions, proposing to triple the number of locations off-limits for firearms. Even as their own attorneys warned the measures might not survive the next round in federal court. Meanwhile, the legal machine shifted into overdrive. Within 48 hours, lawsuits landed in federal courts from coast to coast. Gun control groups filed dozens of challenges, hoping to salvage what they could of local restrictions. Their strategy? Slow down the ruling by any means. Temporary injunctions, emergency appeals, and endless procedural delays. At the county level, over 300 local governments declared themselves Second Amendment sanctuaries, passing resolutions to ignore any future state-level restrictions that might be revived. The battle lines are clear. The gun control lobby is flush with cash and fighting on every front, but the legal precedent is now against them. The era of permit power is collapsing, and the opposition is scrambling to build a firewall before the next wave hits. Sensitive places are the new legal battleground. Within days of the Supreme Court's decision, lawsuits targeting carry bans in public transit systems landed in federal courts from New York to San Francisco. Plaintiffs argue that subway platforms, city buses, and commuter rail stations have no special carve-out in the Constitution. So why should a morning commute be treated like a courtroom? Judges in 3 circuits are already juggling emergency motions to block these bans, and oral arguments are scheduled within weeks. Parks are next in the crosshairs. In Illinois, a group of parents sued the city of Chicago demanding the right to carry in Millennium Park, pointing to founding-era traditions that allowed armed travel through public greens. Meanwhile, California faces a fresh challenge over its blanket ban on firearms in all state parks, with plaintiffs arguing that picnic tables and hiking trails aren't sensitive places under any historical test. These cases are moving fast, with federal judges split on whether modern safety fears can override a right rooted in the Bill of Rights. Every ruling now has the potential to redraw the map for where Americans can carry, one venue at a time. Federal courthouses are bracing for the next wave. In the weeks after the Supreme Court's decision, appellate judges across the country began issuing orders, some upholding new carry rights in full, others carving out exceptions for so-called sensitive places. The result? A patchwork of rulings that looks nothing like a settled law. In the Fifth Circuit, a panel struck down bans on carrying in public parks, citing founding-era tradition. Meanwhile, the Second Circuit moved in the opposite direction, upholding New York's restrictions on subways as a matter of public safety. Legal scholars are calling it the most dramatic split on gun rights since McDonald. Judges are openly clashing in their written opinions. One in Chicago warned that the Supreme Court's language leaves no daylight for modern restrictions. Another in San Francisco insisted that history allows for urban carve-outs, especially where crowds gather. The commentary is sharp, and the stakes are obvious. With split decisions predicted in at least 3 federal circuits within the year, the path back to the Supreme Court is all but certain. Every new ruling adds fuel to the fire, as both sides race to define the boundaries of the Second Amendment in real time. The next chapter in this legal battle is already being drafted in courtrooms from coast to coast. Over $1 billion in annual permit fees vanished overnight following the Supreme Court's 9-0 emergency decision. For more than a century, states relied on permit systems, often criticized as barriers and revenue streams. This ruling, supported by 15 states and left unchallenged by the Department of Justice, marked the first time federal authorities recognized permitless carry as a constitutional standard. Yet, not all questions are settled. Ongoing lawsuits in California, New York, and Illinois challenge new limits on where firearms can be carried, while appellate courts remain divided on sensitive places. Internal Department of Justice memos, now public, confirm concerns that permit laws were on shaky legal ground after Bruin. As of today, over 300 counties have declared themselves sanctuary jurisdictions for permitless carry. The historical record shows an era ending, but legal and political battles continue. The implications for law enforcement, state budgets, and individual rights are unfolding in real time.